Any mention?
Yes.
Proceed. May I pick to item number this 9.
Who's the other side?
Mr. Jha, already I talked to him.
No one is there for the
He
respondent.
was here, yeah, I talked to him.
When do you want it?
This is a matter of compulsion. It's 3 weeks, Your Honor.
Why such a long time? It's a
Because
confusion.
some information is supposed to pay, but it was not received. It is supposed to come from Calcutta.
On the prayer made on behalf of Mr. or made by Mr. R. Devnath, counsel for the respondent. This is matter after 3 weeks. Yes.
Please, Your Lordship.
Yes.
I'd like to mention item number 12, Your Lordship. The daily cost list. Your Lordship, the matter may come out after 2 weeks.
No objection. You are for the petitioner.
Yes, Your Lordship.
This is criminal.
Yes, Your Lordship. It's appeal against the conviction.
In a
It's appeal against the conviction, Your Lordship.
conviction in what
In
case?
criminal appeal, Your Lordship.
Convicted under
Yes.
what section of law?
Section 376, Your Lordship, IPC.
The remaining appeal is remaining pending.
Your Lordship.
Quite such a long time.
Actually, the conducting counsel is not keeping well, Your Lordship. That's why.
Anyway, on the prayer made on behalf of the petitioner, this is matter after 2 weeks.
Highly obliged.
May I please, Your Lordship? I'd like to
Yes.
mention item number 13. 13 and 14, Your Lordship. Both are connected matter, Your Lordship.
No objection. No objection. No objection. You are for the petitioner.
Yes, Your
When do you
Lordship.
want it? When do you want it?
After 2 weeks, Your Lordship.
It's 13 and 14 both on the request of the petitioners. This matter after 2 weeks.
Yes, a pleasure, Your Lordship.
May I please, Your Lordship? Your Lordship, I'd like to mention item number 10.
10. Yes.
Let this matter come under 6th of October, Your Lordship. On 6th October.
Why 6
The
October?
conducting counsel is from Guwahati. He have other matter in the other court, so.
So he wants us to accommodate on the same day.
On
Not
same
possible. We will not do that. This court will not go the convenience of the council. Glad adjournment will not give you a fixed date.
It's okay, Your Lordship, as per the convenience of Your Lordship. As per the convenience of Your Lordship.
Yes. Give it after 1 week. After 1 week. You are appear for the respondent.
Respondent number 1 to 3, Your Lordship.
This is matter after a week. On the prayer for the learned counsel for the respondent number. You have no objection.
No objection.
Learned counsel for the respondent.
May I please, Your Lordship? I'd
Yes.
like to mention item number 4. My senior is out of station, Your
Item
Honor.
number 4.
Yes, Your Honor.
Part 1 matter. Like you wait for it.
Okay, Your Honor.
Let the matter be called.
Obliged.
Supplementary list, item number 1.
May it please, Lordship.
Yes.
Lordship, here what happens, inadvertently state was not made a party. On the last occasion, on 25th, Lordship was pleased to direct us to file an application. We have filed that application to
What?
make the state
What?
a party.
No, there is no direction for filing application. The order doesn't say so. It was a simple request on the behalf of
There was a
petitioner.
request made, and Your Lordship had allowed the request to implead the state, but no formal order has been passed impleading the
Order
state
was
as a
not there,
party.
but
In
it
this
was-
matter? No,
Yes,
no,
but
no.
I don't see why the state should be a party. It's a
Definitely
criminal
it is.
petition, Your Lordship,
Lordship, it's a
and
matter
then no relief has been claimed
No,
against the
there
state.
is no such order. Where is that order where state is required to?
That is what they have mentioned in the state,
no, no.
I mean in the application for impleading.
There is nothing.
If not necessary, Lordship, we may proceed perhaps.
No, it's up to you. See, like whether you at all. But then, if you speak about the orders passed by this court has not passed any order.
Lordship, there is an application filed on the direction that let that be application filed.
This application is not maintainable because there is no prayer against the state.
Your
No
submission
relief
is
has
not
been
supported
claimed.
by order.
Lordship,
So please.
okay, because the prosecution is always state, even if it is a complaint case. That is the reason why
If
You
it is
were
a
never a
complaint
party, Your
case, why
Lordship.
state
it is a
why state
complaint.
is
trial
required?
court.
it is a complaint case.
Why state is required?
You were never a party before the trial court, Your Lordship.
As per criminal procedure code, Lordship, normally, even if a complaint is filed, if a complainant engages an advocate, he is deemed to be a public prosecutor for the purpose of complaint. That is the reason why,
Public prosecutor, that means a state becomes a petitioner.
yes, Lordship, complaint.
Then you are public prosecutor. If you are a complainant, then
I was not complainant, dear Lordship.
So I think
when
this-
they are represented by the private advocates, I do not know what submission you make.
Anyway, Lordship, now today is the case fixed
It's a
for
request.
just motion.
Yes, but then what about your other application?
Other application
State is
state law is
not prepared. You just
State is
wait.
neither a necessary party nor a proper
You cannot
party in
make
this
that averment
matter.
that the court has this thing.
So I pray that this application for impleading the state may be dismissed, Your Lordship.
application. Miss case 70 was actually filed. It was not with the perhaps record.
There is nothing on the record.
Nothing, Lordship.
But then why do you
because,
want to
because,
investigate?
because Lordship, the cause list does not reflect it. That is why we have also seen. And the copy to the petitioner also served actually on 26th. A copy
Not
of
to the
petition.
petitioner, to the state. I received a copy on the
No,
26th.
there's simple prayer for adjourning the matter was made. And that is what has been done. But then nowhere it has been stated.
Okay, Lordship, I'm submitting to the point of that Annexer 2 and Annexer.
No, what is to be done with your miscase first? 70, miscase 70, that's the
Miscase 70 is for just impleadment, nothing, Lordship, otherwise.
With whether do you want to press it or we can dispose it off without being pressed? The state is not required to be a party.
Actually, we have filed to press it to make the party because of that.
What role they are playing here?
For the law, Lordship, that is the reason that any prosecution, even if it is a private, state should be the party.
Where is that? Show me that.
Right
Yeah, let in the court, please.
Right now, Lordship, your Lordship on the last occasion said,
Do not say, the court did not say anything.
no, Lordship, allowed to file that application.
Where is that? On what basis you are saying it? No way. There is no order.
Then Lordship, I will not press it.
May be disposed of.
See, until and unless something is supported by order, please do not make submission. So far as the role played by the court is concerned.
Lordship.
In miscase 70, you're right. The application stand dismissed. No, just say please, landing counsel for the petitioner submits that the petitioner does not want to press the application. The application stand dismissed.
Status represented, Your Lordship.
Yes, that will be automatically.
Pleasure.
You withdraw, you'll just say it's dismissed on withdrawal.
Withdraw, Lordship.
Yes. Then press on answer, the application dismissed on withdrawal. Yes. Yes, come to your main petition.
Lordship, here the impugned order is at page 27 to 30, that is Annexer 2, and Annexer 5, Lordship, from page 41 to 44. And Annexer 6, that is the learned sessions as order in criminal revision petition. What happened, Lordship? The respondent here filed a complaint initially one FIR before Lotasil PS in Guwahati, alleging that complaint I am reading out, Lordship. At running page 21, Lordship, Annexer 1. Here, Lordship,
That is a complaint case, not FIR.
complaint. Here they have mentioned about one FIR where they are saying that they are aggrieved because the Lotus LPS was not working. That is the reason why.
Yes, come to the point where you were to come.
Lordship, now come to para 4. That the complainant during the month of May 2010 had received a telephonic call from the credit manager of United Commercial Bank Silpukuri branch at Guwahati to pay some amount of 89 lakhs to the UCO Bank. And Lordship, it was allegedly, Lordship, taken by the petitioner before your Lordship that he took the amount by depositing some LIC policies of the respondent and took the amount from in the name of complainant. The FIR was not there. It was said to be the telephonic call, and they said that the notice, copies of notice. Next, Lordship, basic allegation was that message the respondent, Lordship.
This is a complaint case of 2012. You are challenging it now after 11 years.
Yes, Lordship. That was not looked into by the Lotus LPS. Subsequently, he has filed this complaint before the Nongpo Lanet
CRK is filed in 2012.
12, Lordship.
And you have not entered appearance in this case. Have you entered appearance in this case?
No, Lordship. No notice has been served. Lordship,
It is just pending like this matter.
yes, Lordship.
You do not have the knowledge of this.
Yes, Lordship. I would like to take your Lordship to the Annexer 5, Lordship. The judgment of the learned district and session judge.
District and session judge.
Yes, Lordship, it starts at page 45, Annexer 6.
This is a revision.
This
Order
is a
passed as
revision.
a revision.
This is a revision.
Who filed the revision?
Revision we filed, Lordship.
Then you said you have no notice, you have not received, you have no knowledge of the case.
No, that was actually in the complaint case we have appeared from the complaint.
That was precisely the question which the court has put you. See, if you are not able to raise the matter properly, this court will not appreciate the things, will not get the things.
The question was, Lordship, the learned CJM passed the order without jurisdiction because
You challenge this, you filed this revision against which order?
Annexer 2 and Annexer 4, Lordship.
Let us come to Annexer 2.
Yes, Lordship.
Show us take us to the order.
For appearance, Lordship,
Where is Annexer 2?
Annexer 2 at page 27.
Yes, let us come to order. Let us see. What is the order? Yes, it was passed in 2014.
2014.
Yes.
Lordship, here an application was filed by the
Please read
respondent.
the order. Please read the order. Let
Yes,
us see the
Lordship.
order.
And ultimately, when we did not appear, Lordship, it was ex parte
Please let
yes,
us read the
Lordship.
order.
that concerned net fee Northeastern Development Financial Corporation Limited, Ganeshguri,
Are you reading the
Guwahati.
order?
Reading, Lordship, last.
Which part, last part? You read the entire order.
No. Okay, Lordship. At page 30, Lordship, typed copy.
Yes, it is 29 here, not 30. Order starts at 29, page 29.
29 type copy, from 27 the original copy, the letters were small, so type copy was given.
Type copy is
Okay.
starts at
Okay,
it is at
Lordship.
page 29. Please read from there.
I am just concluding part I am reading out.
No, you just read the entire.
Lordship. Seen and perused, CR put up today along with petition number 19 of 24, 2014, dated 10/2/2014, filed by the petitioner complainant, Sri Benning A. Sangma. Seen and perused the said petition wherein the petitioner complainant has stated that the accused is trying to take back with malafide intention his original documents submitted as securities to Netfi, Ganeshguri, Guwahati, for a term loan of rupees 4 crore and 3.4 crores to the State Bank of India Barnihad branch, in addition to the land mortgaged by the complainant as collateral security. So that is how the documents were deposited, which in fact Barnihad branch SBI. The petitioner complainant also states that the accused opposite party had misappropriated, diverted the funds of the company for which this instant case has been filed against him under various sections of IPC. So the petitioner complainant is afraid that once he succeeds in taking away the original documents deposited as additional securities, the company, that the name is there, Seven Sisters Plastic Private Limited, will incur a heavy loss, as accused has diverted huge amount of money during his term as director. Therefore, he prays before the court to direct the Netfi, Ganeshguri, Guwahati, and the State Bank of India Barnihad branch not to allow Sri Dinesh Kumar Mittal, that is the
In a CR case?
Lordship.
It's a civil case or criminal case?
That is the reason why we have been before your Lordship.
Anyway, this order is passed in 2014. Then what happened?
That means
So let us see the operative part.
operative part, Lordship, may come to page 30,
Yes.
last para, Lordship. The concerned Netfi Limited, Guwahati, as well as the State Bank of India Barnihad are hereby directed not to release the documents deposited as additional securities to Dinesh Kumar Mittal, who is the accused in this instant case. Further allow him to withdraw the security.
This is in 2014. Injunction order. Yes. Then?
Yes, that is what is the injunction order.
Okay. Then you challenge it by filing a revision.
What happened, Lordship? Not this. Unfortunately, this was not done.
This challenge order was not challenged.
Not challenged. Subsequently, what happened? It was passed ex parte, Lordship. Just before this para, what happened in the complaint revision sorry.
Yes, the accused did not appear. Okay.
We did not appear.
Yes, it was an ex parte
Before
order.
that, ex parte. Thereafter, Lordship, what happened? We filed an application for vacating the earlier order to consider afresh.
Where is that? Where is that order?
That order is, Lordship, at Annexure 5, page 41, Lordship.
41. That was in 2019. After
That
5
was in
years.
19.
2000.
After 5 years. Maybe, Lordship, what happened? We filed that application, and that application was in fact not considered or not allowed on the ground that I will come to, Lordship.
No, you approached the same court for getting the order vacated.
Yes, Lordship. Next question comes before your Lordship is that
What is the order then?
order Annexure 5, Lordship.
Yes, and what does it say?
Yes. Here put up today, learned counsel for the complainant and the accused are present. Learned counsel for the complainant.
Comes to the operative part. So what
Operative
you want
part,
to
Lordship. Page 42, Lordship.
say? Yes.
It is also seen. From that, I would like to.
Okay. Yes.
Second para, in fact, in the 42nd page.
Yes.
It is also seen that by letter number 10/12/2018, the Assistant General Manager cum Central Public Information Officer, Regional Business Office of State Bank of India, Shillong, Rural, on record, the accused petitioner was informed that the loan account of Messrs. Seven Sisters Plastic Limited has been taken over from the book of SBI Barnihad branch by South Indian Bank Limited on 28/2/18, and that accepted the liability of guarantors to the bank ceases upon payment of all dues by the principal, and accepted the liability of mortgagors to the bank ceases upon payment of all the dues by its principal. That is what is the case, Lordship. South Indian Bank has purportedly taken over the loan, and that is why this SBI Barnihad branch has no scope to retain it, because they have issued also one clearance certificate, Lordship, no due certificate. Lordship, it was submitted by the learned counsel for the accused that the documents submitted by the accused petitioner as collateral securities before the bank is not subject matter of the case, and are not, in the criminal case what has been referred to, and are not relied upon documents, and as such not required in trial, and so it would not in any way, in any manner prejudice the complainant, nor cause hindrance or in adjudicating the case, if directed to be released to the accused petitioner. The learned counsel for both the petitioners and accused and the complainant were heard on the last date fixed, and till date, as submitted by the learned counsel for the complainant, the South Indian Bank, since then, Lordship, South Indian Bank Limited has not submitted any letter of intimation to the complainant as required by the complainant in the said letter dated 28/8/19, considering that as per objection raised by the complainant, that another case is pending in the court of the civil judge number 2, Kamrup Metro Guwahati, being TS number 487 of 247 of 2014, relating to the state original documents.
You refuse to vacate the order. Against that, you filed a revision.
Lordship,
Now, the entire proceeding seems that it was not a proceeding before a criminal court. It is something like a civil court.
yes,
In
Lordship.
2014, the court passes the first order. You challenge it in 2019. That also why you surrendered yourself to the jurisdiction of court, and you file an application for vacating the stay, the interim order.
This is what is there, Lordship, because Lordship.
Then you file a criminal revision. Now, what is the order passing criminal revision? When this criminal revision was filed?
It was filed in 2019, Lordship.
No, this your order is
4 of
also
19.
2019. Immediately thereafter.
Lordship, at page 45, it starts Annexure 6.
Yes.
47, Lordship, it starts, the order starts. Here the learned session judge, in fact, hold that the previous order, Lordship, was not challenged. That is the reason why the learned session judge did not interfere with the order dated 13/9 when it was rejected.
It's okay. We'll issue notice since you have approached. Seems like you have a good case, but then we'll issue notice. Let the other side appear.
Okay, Lordship.
And then
Highly obliged, Lordship.
hard. Please give your name.
L. Talukdar.
Learned counsel for the issue notice. Returnable in 3 weeks. So, petitioner to take steps for service of notice upon the sole respondent within 2 days. List after 3 weeks. You take steps for service of notice.
Lordship.
Never like a criminal proceeding like this.
Lordship, that is the thing, Lordship, where civil court jurisdiction was exercised. That is why,
You surrendered to the jurisdiction. You should have challenged the very first order.
Lordship,
Not going to that court, you should have challenged by.
Lordship, after only revision, we have come before your Lordship.
Main list, item number 1.
after the receipt of the episode.
May it please your lordship.
Yes, you not filed your affidavit.
We need some more time, your lordship. 2 weeks. 2 weeks time may kindly be
2 weeks
allowed.
Yes.
Why so over the sought for time?
Lordship, investigation is going on, your lordship. We'll file a short affidavit, your lordship.
As per file. On the prayer of the, in the prayer of Mr. Andy Shulai, learned AG, further 2 weeks time is granted to the state for filing affidavit in opposition
Apply, lordship.
on behalf of the state. List after.
Item number 3.
May I please, your lordship?
Yes.
Let this matter must become up next week, lordship. Conducting counsel is out of station, lordship.
All have been served. Everyone, all the respondents are appearing.
Your lordship, on the last occasion, the submission is made to produce some document on record, your lordship.
Last order only says that as on the prayer of the Land Council petitioner, list this matter after one.
Submission is made in the courtroom, your lordship.
What documents are needed? This is what application?
That's the thing, your lordship. It was unclear, your lordship.
That is, this is a petition. What? This is for what? This is an application for what?
Last occasion, lordship, the compromise letter, the date was not reflected that one. The date was be there, lordship.
And this is a application. This is an application under 482.
Yes, lordship.
What? Seeking quashment of what?
FIR Act.
Okay. The settlement by the complainant and the accused.
Yes, lordship.
You are appearing for the accused. Accused. Oh, sorry, you are the complainant. Complainant. And you have settled the matter.
Yes, sir. They have executed during the pendency of the case, lordship. They have executed the compromise deed, lordship.
Yes.
So you admit that there is a compromise deed.
Yes, lordship. There was a. We have annexed compromise.
Now, that is all right. So you are not disputing it.
No, lordship. We have no objection.
You have no objection. Now, what is the hurdle then? The law.
Next week, lordship.
That you have to take care.
Yes, your lordship. Your lordship, let it come up on the next day when the parties are.
Yes, lordship.
Now it has become a trend in all the criminal cases. File FIR and then thereafter execute an agreement and then say we have settled, please quash it. Anyway, just wait for by the landed counsel for the petitioner. This is matter after
1 week, lordship.
1 week.
Highly obliged, lordship.
Item number 4. Release. Hearing. Item number 2.
Yes.
This is the matter, my lord, the husband and wife, the contract matter.
Yes, yes. My lord, Mr. Day.
My lord, what happened, I've communicated, my lord, that if they can recall the blacklisting part, my lord. So your lordships recollect on the last occasion.
Yes.
So what happened, my lord, the DG and ADG both are out of station, my lord. So I'm praying for 10 days time, my lord. In the meantime, most probably we will come out with a solution, my lord.
My only prayer is, my lord, if they are seeking to recall it, it should be recalled ab initio, otherwise the stigma would remain.
That is what has been submitted on the last occasion also. The Senior Counsel has been informed of that.
I have no.
I've conveyed that to them.
So there remains no stigma on it. That is what.
Yes.
It's okay. Then
6th. 19th. On 9th, my lord.
9th or 10th that week, my lord.
list is on the prayer of Dr. N. Mujiga, learned DSGI. List is matter after 10 days.
10 days.
Will it come up on 9th, my lord, because the petitioner comes in person every time, so he is requesting on 9th, my lord, if it can be fixed on 9th.
Well, you will come after 10 days. We are not giving a fixed date.
Oblige.
Main list. Hearing. Item number 6.
May it please your lordship.
Yes.
Lordship senior conducting counsel is on legs, lordship.
So you will argue that matter.
Lordship.
You argue?
Lordship, I'm on very limited instructions, lordship. Lordship, I'm praying if this matter may be
So you
listed.
argue with that limited instruction, there is no problem. What is there? What is the matter about? At least tell us that what is the matter about.
Lordship, we had in this matter we had prayed for a direction from this honorable court so we had applied for
That amount of subsidy.
capital. Yes, lordship, capital investment subsidy.
Whatever you got, that's not sufficient.
No,
You want
lordship.
more.
Lordship, we had actually submitted for 44 crores, out of which 26 was.
So you want 44.
Lordship,
Nothing less
we
than.
had.
You will not come down.
Lordship, our investments.
So you are not ready to come down. You want 44.
Lordship.
Yes, Dr. Mojiga says they want 44.
As far as I know, this company is defunct now. Out of business.
No. As a matter of fact, how this court will determine the rate? Is there any sufficient materials provided with the writ petition to show that your assessment was utterly wrong or it is not in accordance with
Mainly,
law?
what happened, my lord?
Was there any laid down formula for making calculation in the?
My lord, here is not about calculation, my lord. Here is about because subsidy was given on plant and machinery, my lord.
Yes.
Under the central scheme. If a new plant and machinery is purchased, then not on second hand machine.
It's 100% subsidy.
But there's some different percentage, my lord. Now what happened? Mining equipments are not included there, my lord. They are claiming that is one of the dispute, my lord. They are
No, but
claiming mining.
whether mining equipment is included or not included,
The plan.
what basis we decide? Is it provided in the scheme itself? Say supposing when any claim is made
My lord.
for subsidy,
My lord.
definitely they give their own estimate.
My lord.
And thereafter you have your assessing process. Is it?
My lord, that is our case, my lord. If I may take your lordship to page 23, my lord,
Of the writ?
of the writ petition, my lord.
Yes. Paragraph 20.
At page 23, my lord, of the writ petition. Sorry, this is affidavit, my lord. Sorry.
Your affidavit.
My lord. Here you have said that these are the exclusions at serial number H, my lord, capital H, at page 23.
It's page 23. Page 20 is a part of annexure, isn't it?
Yes, my lord.
Annexure 2? No.
Yes, my lord. Annexure 2.
Plant and machinery for a typical cement plant.
My lord.
And then which clause you are referring to?
I'm referring to next page, my lord. Page 23, clause capital H, my lord.
H. Exclusions.
So these are the exclusions, my lord. Workshop equipment, laboratory equipments, equipment for power distribution.
So that means there is a standing order to do that.
Well, this is the part of the scheme, my lord. The
This is
NHSC.
part of the scheme.
And here it says, my lord, mining machinery at serial number 6, my lord.
And what their case is?
In their case, they are including the mining equipment, mining machinery in the plant.
That should be included. But then as per the scheme, it is not.
My lord. That is our case, sir.
He's asking for time.
My lord.
Yes. When do you want it?
Lordship, after 2 weeks.
This is also, madam, quite old, madam. 2014, madam.
Lordship,
It should be taken up. If senior counsel is occupied, you should take it. And if the matter is limited to the issue which the senior counsel said, then I don't think it will be that complicated for the court to understand.
It's not complicated. Very simple. It's heard many times, my lord.
Yes, right on the prayer of the petitioner. It is this matter after 2 weeks. So you are not objecting to, are you objecting to this thing? Well, this is the concern is for the court now, it's 2014 matter.
14 matter, my lord.
Please make sure you do not ask for time, you see. Otherwise, you will pass an order saying that this is last chance. If it is last chance, then you will have to take. And just say on the prayer of sunset after dispute after 2 weeks.
Obliged. Item number 7.
Yes.
Lordship, I'm seeking for some accommodation in this matter.
Again, same prayer. Objecting or not objecting?
No objection, Your Lordship. Here, Your Lordship, in this petition, many dispute of facts are there, Your Lordship. Whether this court can salary, regarding salary, whether it's in service, there are 2 schools, dispute school, fixed school and real school.
We will just see, try to see.
Okay, sir.
If you can locate the dispute, we may try to settle it. If you cannot locate, then we will go to civil. I do not know wherever it is. If it is.
The settlement was paid for, but it appears that it never happened.
Yes, yes, that I think.
Only for the salary, Your Lordship, because it's pending with the then secretary who has expired, 9,400. We are also admitting that with the then secretary. Only 9,400.
So far as that amount you are ready to
give.
But they are not ready to accept it. They want more than
because
that.
They're claiming that she's still in service. But as per records, she has
9,400. How it will serve? See, their cause will not be served. You should understand. See.
2,000. The salary is for 2,004. Only the 1 month before she is terminated.
Thereafter, she has opened another school with the same name. So that
Fixed
is where
school.
the government comes into play, and we have given our report. And 2 reports are there, wherein our director, higher and technical education, was asked to give a detailed report. After the receipt of the report, they again started coming back without challenging the report. They are again going to the main writ petition and saying
Termination or also not.
You are appearing for? Anyway, we'll just see to it. If you are not seriously objecting to the prayer of adjournment. This is also 2014 matter.
Yes, sir.
Okay. So on the prayer of the learned counsel of the petitioner, is the matter after 2 weeks.
Obliged.
Obliged, Lordship.
Item number 8.
So we have similar prayer, Lordship. similar prayer, Lordship, in this matter.
Like both the senior counsels are on legs, my lord. Even Mr. K. Khan and Mr. K. Paul in the other courtroom, this case. Being led by Mr. K.
So you were the only one ready for argument.
Yes, I have objection, Your Honor, because ever since I was not been able to place the case in accordance. I have filed my affidavit since long time. And
We are the beneficiary of
I'm deprived of possession and.
You are the UMP defending the
Yes, our
read
action
petition.
is being benefited.
So you have a limited role to play. You will have
Yes,
to be dependent on the state.
Yes, but I have certain law points as well to submit, Lordship, on this issue.
But then what to do if senior counsels are not appearing with their own legs?
Yes.
To go by the tradition of the bar.
Yes.
Short didn't be
Short did be fixed, Lordship.
After a week?
That will do.
Again, on the prayer of the petitioner, this is matter after one.
You obliged.
I'll be obliged.
Item number 11.
14, 15 minutes. Yes. Oh, yes. Yes.
So, my lord, respondents were supposed to get some
not
instructions.
audible.
I don't know what it is. My lord, the respondents were supposed to get some instructions.
Increase your
what
volume,
these
Mr.
instructions have come to them or
Siddiqui.
not.
Please increase your volume.
Yes, my lord, am I audible?
Yes.
Yes. So, my learned friend was supposed to get some instruction. So, I don't know what they have.
Yes, my lord, I have it. My lord, there's one technical difficulty in this petition, my lord. My lord, here what happened? They've only arrayed Assam Rifles as a respondents, my lord, in the present.
What is the subject matter of the case?
My lord, here what happened, my lord? A recruitment rally was held, my lord. In the recruitment rally, though provisionally the petitioner was selected, in the medical examination he was found to be suffering from some ailments, my lord. So some hearing related, my lord. And because of that, he was disqualified on medical ground, my lord, and then he has come before the Supreme Court. Now the difficulty, my lord, because earlier there was a separate recruitment rally by all forces, my lord, or paramilitary forces. Now staff selection commission.
It's a combined rally.
It's a combined test, my lord.
Yes.
Now what happens, my lord? Only because staff selection does not have their own medical team and all that. It is something like UPSC, my lord, or MPSC. They conduct only the exam, but medical test and other things they take help from CRPF, from Assam Rifles.
Exam is held before medical test. Or medical test is done prior to exam.
Exam is 3 stages, my lord. Exam consists.
No, it starts with medical or?
No, my lord.
It ends with medical.
It ends with medical, my lord.
You allow all those unfit persons to take part in the exam and then you disqualify.
Because what happens, my lord, otherwise there are lakhs of people, my lord, to conduct medical examination unnecessarily for them, my lord. So first is the computer-based some written exam, my lord. Thereafter there is a physical test, running and all that. And if they qualify both these, then they are sent for medical exam.
Now they have challenged that thing, that disqualification on medical ground.
Medical, my lord.
Now you are supposed to take some instruction on what?
My lord, instruction is that, my lord, CRPF is was the nodal agency for medical test, my lord.
Was there an order passed by this court specifying that part? The last order is only a grant of time for obtaining instruction.
My lord, order dated 19/7, my lord.
Yes.
The question came up, my lord, that why CRPF guidelines are followed when the recruitment or the medical test was done by Assam Rifles.
Was it? Is it something illegal?
No,
Assam Rifle has their own medical thing.
My lord, every force has their medical, my lord.
Yes.
But
medical
for recruitment, because it is a composite for all forces, my lord.
Yes.
So what happens? CRPF is the nodal agency to conduct.
Now, was there any difference with regard to the guidelines of CRPF and Assam Rifles?
My lord, here what happened, my lord? We disqualified them on certain ground, my lord. The nasal, we found some problem with that, my lord. He went to civil hospital Shillong, my lord. He brought a certificate from there that he is fit. Then we sent him back for review medical examination. This time he was found to have a problem with his ear.
Initially nasal and then ear, my lord. Then he did not bring any second time fitness certificate.
Second time he again went to Negrims, he brought another certificate that he is fit.
Then third time you again said it. Then you found problem with his eye.
No, my lord,
okay.
It stopped there, my lord.
You stopped there?
It stopped there.
So now you take him as a fit person or not? Now then what for we need this? Say supposing if there is not much difference between guidelines. Say supposing, assuming that Assam Rifles has separate guidelines and CRP have separate guidelines. And if there is no real difference between the
guidelines. My lord, in my humble submission at this stage, my lord, because the recruiting agency was staff selection, my lord, SSB.
Staff selection is a party here.
It's not made a party. Even CRP
Mr. Siddiqui, staff selection is not required to be made a party here.
Well, we are not agreed by any action of them. We are agreed by the Assam Rifles only, my lord.
Now,
it is they who have taken us to agree on
this medical test was not a part of selection process.
It was, but later on when they found us to be unfit.
No, say supposing.
Appeal, it is they, Assam Rifles, who took it.
Yes, say supposing this medical test medical fitness is also part of a selection process. Then how can it be separated in that way? Then SSC will remain responsible for that, irrespective of the fact who conducts or whose guidance is followed.
It is the Assam Rifle which took me to Nigrim.
Yes.
And Nigrim found me fit.
Okay. You take
that
it
is the
to
case
Nigrims and you find
because
me
of
fit
them that I do.
This is something not very fair.
Yes, my lord.
My lord, what I am submitting, my lord, that your lordship will examine, my lord. But in the absence of staff selection commission, whether any proper relief can be granted, that is a question, my lord.
What is the advertisement?
Ultimately, the advertisement, my lord, page 9 of the writ petition, my lord. Advertisement issued by staff selection commission.
Page 9.
Page 9.
Let us see, Mr. Siddiqui, what is there in your petition.
Yes.
Connection was page 9 is the application form.
Is the application form addressed to staff selection commission?
Yes. Where is the advertisement? And where is that part which says that it will be subject to medical fitness and all those things in the advertisement? Where is the detail with regard to medical examination, Mr. Siddiqui?
My lord, in their affidavit in opposition at page 6, paragraph 8, affidavit in opposition.
Page 6, paragraph 8.
Yes.
Yes.
It says that with regard to the statements and averments made in paragraph 8 to 11 of the writ petition, the deponent denies the same and states that during RME on 12th October 2020, the petitioner showed signs of injury in his ear as observed by the review medical board subsequent to the same as per para 7 of the Directorate General CRPF guidelines dated 4th September 2020. The petitioner was referred to Nigrim by them for ENT specialist opinion with reference to the deviated nasal septum right and chronic suppurative at his media right ear. During detailed examination by ENT specialist at Nigrin, pure tone audiometry PTA was conducted for the petitioner, which revealed that petitioner has high frequency hearing loss. However, despite the hearing loss, ENT specialist declared him fit because the petitioner was referred only for review of deviated national spectrum. So, my lord, here they have said in the Nigrim report it says high frequency hearing loss. But if we look at the ENT report by the Nigrim, these words are not at all there.
So you are disputing that there is a contradictory medical report.
No, my lord. Actually, this is the affidavit in which they have said like that. Otherwise, in negative report, it says something else. It does not say high frequency loss, my lord. Their finding has been said at Annexure 8, Annexure 8, page 19 of my read petition, my lord. That report is the negative report.
No, but then in that your advertisement doesn't say that anywhere that there has to be a medical test and all those things. Nowhere it is mentioned. And you will be subjected to the test, and by whom?
But that matter has been set at rest because it is the Assam rifles which referred me again on appeal to the Nigrim. It is not me who has gone
That is all right, but then let us pass. See, these are the things, whether that has been done correctly or not. For determining that, we first need to see, as per the normal procedure, what is to be followed. Now, that is what basically needs to be placed before the court, before we go to the other things, that what should be binding and what should not be binding. Now, we must understand what is the normal procedure to be followed for determining medical fitness of a person, as per the recruitment policy.
Well, if the matter can be taken the next week, I will try to clarify that position on that point of that what should be the procedure.
That is what will be required to appreciate what you say, what your contention.
Yes, ma'am.
Reading that. And what about your instruction? What you were supposed to take, Dr. Majika?
The instruction was that why CRPF guidelines are followed.
But then, if that is the order, then you have to take that.
My lord, I have a instruction on that, my lord, because the nodal agency was CRPF, so CRPF guidelines are followed.
The advertisement has not been enclosed anywhere in the petition.
It's not there. My lord, in my affidavit, I have taken that plea, my lord, that Staff Selection Commission and CRPF should be made a party. Otherwise, no effective relief can be given.
CRP may not be necessary, but then staff selection
is very necessary.
I don't know. That is why you need to see the advertisement. Without seeing the advertisement, it's very difficult. If, say, supposing if a writ petitioner is entitled to some relief also, in such a case, to whom direction should be issued? That is the main thing.
Because not necessarily that he will be appointed in Assam Rifle, but it is up to Staff Selection Commission.
Can be appointed somewhere else.
To ITBP, to BSF, to CRPF, to any.
Then why he's only why these officials of Assam Rifles are only respondents, Mr. Siddiqui?
Because it was for the purpose of Assam Rifles. This appointment was to be made for the Assam Rifles.
Where from you say?
Absolutely not, my lord.
Where is the advertisement? Where
is application says, my lord, at page 9 of the writ petition, my lord. Staff Selection Commission, I have indicated, my lord. Constable GD in CAPFs.
Yes.
NIA, SSF, Rifleman GD in Assam Rifles.
Yes. Mr. Siddiqui, your application was not confined only to Assam Rifles. Please come with a copy of advertisement.
My lord, let's come next week. I will examine this part.
Please.
If necessary,
otherwise it will be difficult for the court to come to a correct conclusion. We'll just say on the joint prayer, this matter will come after 1 week.
Yes.
We just say on the
2 weeks, my lord. Maybe 2 weeks, my lord, because I'll have to.
Yes.
2 weeks, if you're not.
You have 2 weeks already? On the joint prayer made by the parties, this is matter after 2 weeks. If matter becomes a puzzle for the court, it is difficult to come to a conclusion.
Actually, what happened?
At least if you have all the data and materials, it becomes easier.
Actually, what happened, Mr. Siddiqui, is there, my lord. When he was taken to Nigrims, so nasal problem was not very serious, maybe. But when his ear test was done, now the question may come whether he was not sent for a review medical board for ear problem.
No, we have to see to what extent you go. to determine medical fitness of a person in a selection process.
My lord, that is the
You cannot
rules.
subject him to all those thorough checkup to derive your satisfaction. It may happen that you do not like somebody, you want to oust
My lord, it is something like that. I went to a doctor for checkup of fever, my lord. Suddenly, doctor, while doing all kind of tests, it came out that I have some other problem also.
No, but then if you
How
have
can we ignore that other problem? My lord?
if
That
you
is-
have taken him, taking him to Nigrims was at your instance, then whatever Nigrims says that should be binding on you.
Well, we took him for fever, my lord, but Nigrims also found that he is also suffering from this disease. my lord.
Anyway, we'll see.
No such reason, my lord, it is not that.
Well,
I will satisfy your lord.
Okay, we'll come to the merits of the claims and merits and weights. First, let us understand what is the procedure to be followed. Will you first?
Yes.
obliged.
All right.